Really happy to be here.
Sorry.
Got it. That's okay. I'm really happy to be here, especially talking to people who aren't lawyers, who are working with vulnerable populations, and who might, it looks like we've got a ton of women too. So I'm happy to share resources with you and tell you what the law defines as discrimination, harassment, especially in the gender context. So I'm going to share my screen. And then hold on, I gotta click present. There we go. Okay, is that taking up the full screen? Yeah, okay, great. Okay, so I am an attorney at the law office of Jaburg Wilk. Jaburg Wilk is a full service firm, but we have an employment team that specializes in representing plaintiffs. So we represent people who have complaints against their employers. This is pretty unusual for larger firms because employers have more money than employees. So bigger firms tend to like to represent the employers rather than the employees. But we like to represent the little guy in this particular context. And just to brag on my team a little bit, we just won a $500,000 jury verdict against the city of Phoenix in a sex harassment case. So we are super pumped about that. We feel really strongly about these issues. So that's why I'm so glad to present to you today. So we're going to talk about sex discrimination specifically, and there are really two applicable laws here. The first one is the federal law, which I'm sure all of you have heard of, the 1964 Civil Rights Act. Title VII is the language that I'm sure most of you have heard about. Employers and the government cannot discriminate against someone on the basis of race, color, ethnicity, gender, or sorry, not gender, but sex, and religion. We'll talk about sex specifically today. Title VII has really favorable remedies, although they are capped depending on the number of employees that an employer has. The statute of limitations, which means the time that an employee has to file a complaint, is really short. And this is true really in the entire employment context. Some statute of limitations are as short as 10 days. Under Title VII, plaintiffs can seek what are called compensatory damages, which are things like lost wages, emotional distress damages, anything that they have experienced as a result of the conduct is recoverable under this law. The Arizona legislature passed its own law that's modeled largely off of Title VII, but they really gutted a lot of the remedies. So I'm sure it won't shock you to learn that Arizona is a very employer-friendly state. The employers lobby has done a really good job of really gutting some of the remedies that are available under Title VII. You'll see that the statute of limitations is much shorter. It's almost half of what it is under the federal law. You also, under the Arizona Civil Rights Act, you cannot get emotional distress damages, and you can't get punitive damages. Both laws have retaliation provisions. You'll hear people talk a lot about whistleblowing, and you're a whistleblower. That's not really a real thing under the law. What they're talking about are retaliation provisions. So both of these laws have provisions that prohibit an employer from retaliating against you because you made a complaint or because you oppose some practice that's made unlawful by this particular law. So it's not, people say I'm a whistleblower. It's like, well, that's not really true if we're strictly talking, what your claims are under the law. And the same remedies apply to these retaliation provisions as well. Both of these laws use the same language. You can't discriminate or take an adverse employment action against someone on the basis of sex. I've noted later that, it's 2022, we have progressed past certain stereotypes of sex and gender. I believe that gender is a spectrum. I believe that sex and gender are very distinct concepts. The law was written by white men in the 1960s, so the language does not reflect what a lot of us know to be true now. So to the extent I use the word sex or gender in ways that, are not, don't comport with what we've learned in the last few years, it's not because I'm trying to be ignorant or, insulting. It's just the way the law uses these terms. On the basis of sex includes pregnancy. So I hear a lot that, women aren't allowed to pump at work. They're not hired because they were pregnant. They're not hired because they intend to be pregnant. Those are all unlawful employment practices. All of those things fall within pregnancy, and pregnancy is included on the basis of sex because women can get pregnant. There's really no way to separate pregnancy and women. If you discriminate against someone because of pregnancy, you're discriminating against them because they're a woman. So if you ever hear your clients tell you that they don't have, their manager isn't letting them pump, they're not letting them, be promoted because they're pregnant, those are all things that can't happen. It also includes now, actually really recently, it includes sexual orientation and transgender folks. Bostock v. Clayton County is a case that was just decided by our United States Supreme Court, and it held that Title VII, the federal law, protects employees against discrimination, either because they're gay or because they're transgender. It was written by Justice Neil Gorsuch, which is a Trump appointee. Pretty amazing that he wrote that opinion. It also speaks to what I call the Black Robe syndrome. Judges who are politically appointed will take very stark, sometimes take very stark political positions before they're appointed. Once they're appointed, these are lifetime appointments, so they can apply the law in whatever way they see fit. And Justice Gorsuch did that, and I think he made the right call. That case also has really, really good facts. So lawyers often tell people good facts make good law, bad facts make bad law. In this case, the plaintiff worked for Clayton County for like 15 years. He was employee of the month a bazillion times. He'd received a ton of accolades. His clients loved him. And then he joined, he was gay and is gay. He joined a recreational softball league for LGBTQ people, and about 10 days later, the county fired him. So those are real, it's not normally that clear cut, but it was great facts to take to the Supreme Court so that we can, now have these other protected classes. So sex discrimination can take a lot of forms, but it really has to be rooted in treating someone differently because of their sex. So examples include not just termination, but failing to hire, failing to promote, performance plans. Employers love to use the very exhausted tactic of papering someone's file before they fire them for reasons unrelated to sex, gender, race, whatever it may be. Giving poor performance reviews, any adverse employment action. It doesn't have to be termination. I mean, I think people think that if they're terminated, that's the only way that they can prove discrimination, and that's just not true. And many gender-based harassment claims are not sexual in nature, and by sexual I mean what we think of stereotypically as harassment, like a man or a boss rubbing up against a woman, asking for dates, asking to see their body or whatever it may be. Generally, sex discrimination happens in different ways, although it does still happen in terms of, explicit sexual favors. And I have a case that I'm litigating right now that I'll talk about that involves that exact scenario. Quid pro quo is another way that you can be discriminated or harassed on the basis of sex. It's really this for that, sexual favors or submission to sexual conduct made as a condition of employment, made as a condition for promotion. This is where I see a lot of underpaid workers exploited because they don't have a lot of money. They need the money. Their boss says, hey, if you give me a blowjob in the back, I'll get you a $200 bonus. That money means a lot to them. So my position is that those encounters are never consensual. There's always a power dynamic at play, especially when you consider the resources and the socioeconomic factors of each party and how they weigh in favor or against those particular people. So sex harassment doesn't just have to occur on the clock. It can occur off the clock, happy hours. It happens a lot at happy hours or other, work-sponsored events where you're not at the office, but you are around your colleagues. It can include social media. It can include, someone coming to your house, which has happened to my clients. It doesn't have to have happened at the office during work hours. It can happen outside of those times. And employers can be held liable for third-party harassment if the employer has notice. So let's say it happens a lot in sales positions. So people who have to go off-site to make sales or do whatever, and they're harassed by the customer or the client or whatever. If the employer has noticed, the employer can't, force the employee to continue interacting with whoever is harassing them. And if they don't take actions to remediate that situation, then they can be held liable for claims made under Title VII or under the Arizona Civil Rights Act. So here is where things get tricky. Normally, sex harassment, if you are going to file a claim, sex harassment you normally can't be a single occurrence. So if somebody calls you a bitch, if somebody, even if they grope you, if it's once, the court is generally going to shrug their shoulders and say, sorry about it, please just move on with your life. That may be different if it's really severe, but severity in this context means like sexual assault. So the courts really don't favor granting somebody any remedies if it's just one particular occurrence. And generally the conduct must occur frequently or over a long period of time, which I realize really sucks. It sucks for victims, but sometimes you just don't have any remedies unless it happened, during the course of your employment, which lasted a year or two. Severe and pervasive can mean a lot of different things, but it generally means it happened a lot and it happened over a long period of time. So things that we may be offended by, but the court or the law doesn't recognize as severe are these one-offs, asking a coworker for a date. If they take no for an answer, then that's not sex harassment. Somebody, gives you a professional compliment, that's not sex harassment. As long as they are being professional about it, they take no for an answer. If you tell them to stop and they do, those types of claims generally aren't actionable. So this is also where it gets messy, and what I don't love about the law is that the harassment has to be subjectively and objectively severe. Subjective is, how did the victim feel? How did this make me feel? Objective is, how would a reasonable man or a woman feel about this? What does that mean? Who's the reasonable person? How do we define that? How does the court define that? Really, what I have to do as a lawyer is describe the conduct in a way that would be persuasive. But when we're talking about reasonableness of the average person, we're not talking about people who are educated on these types of matters. We're not talking about people who, are professors or who have read, literature about what sex harassment is or isn't. We're talking about anyone. The court doesn't limit that to one particular person. So it's really just a matter of, as a lawyer, making an argument that a reasonable woman generally would feel, victimized, humiliated, embarrassed, whatever the case may be. It's up to us to make that argument. But I don't love that particular element of the law because I feel like it misconstrues what sexual harassment is, and I feel like it also diminishes what happened to the victim. But we have to make it, and it's not going away anytime soon. So when you're working with vulnerable populations, I wanted to give you some tools and some practical advice to give them, and then also for yourself when you guys go out into the workforce and you're working full time as social workers. What are some best practices, and what should someone do if they feel like they're being sexually harassed? The first is that romantic relationships between supervisors and employees are always a bad idea, 100% of the time. If you feel like your client is heading there or is getting pressured to head there, tell them no. Tell them that this is a horrible idea, especially if they're the supervisor. But just a blanket rule, don't get involved with your supervisors. Consensual romantic relationships between co-employees are also generally a bad idea. They might create conflict, and they should be disclosed to HR. And the other issue with employees becoming involved with other employees is if one employee is being harassed and the other employee with whom they're in a relationship with, they're a material witness. If those two people are involved in a romantic relationship, that other material witness who might, be able to testify in court and say, this happened to, my friend, that happened to my friend, all of that testimony becomes what we call impeachable. In other words, their credibility is automatically slashed because they're testifying for someone with whom they have a romantic relationship. The other issue with the law is that the onus is on the victim. So if you are a victim of sexual harassment or your client is a victim of sexual harassment, they need to document. The law does not require you to use what I will call the magic words, which is I'm being discriminated against on the basis of sex, gender, sexual orientation, whatever the case may be. But it looks a lot better to a jury. It looks a lot better to a judge. It triggers a lot of protections under the law. And it also gives notice to your employer. So one of the issues that we had in that case that I just talked about against the city of Phoenix is that the client never said, I'm being discriminated against because I'm a woman. So the city took the position that, well, we didn't know. I had no idea. And I mean, they lost that argument clearly, but a lot of employers win that argument. So even though the law doesn't really impose this duty to say those magic words, the reality and the practical advice that I give to clients is be explicit with your employer. Document the harassment, the date, the time, who was there, what happened. Send notice to your employer in writing, by email, by letter of which you make a copy. Anything like that triggers notice to the employer. So if you give proper notice to your to the employer, if your client does, or if you do, what should you expect from management or HR? Now, here's a big problem that you all are going to have is you'll probably work with populations that don't have, that work for companies or people who don't have HR departments, or, you know, the boss is the person, the boss is also the owner. They don't, you know, have separate legal counsel. It's just not as formal as it would be, say, if you worked at like Target or another big corporation that has all these, you know, processes in place. But what you should expect is an investigation, appropriate action. So that means separating people. It means not requiring the employee to go out and, you know, deal with a third party who's harassing them. It also means no retaliation. So those whistleblowers and anti-retaliation provisions I talked about earlier, those are all triggered if they take adverse action because somebody reported something to be unlawful, or because they reported harassment of another employee, anything like that. And like I said before, adverse employment action is not just, it's not just termination, and it's not just formal written performance plans. People should be cognizant of, a lot of times what happens is employers will divest employees of authority. They'll undermine them. They will take away their ability to make decisions. They'll take away their ability to serve on committees or things like that. Those are all adverse employment actions under the law. It doesn't have to be as clear cut as you're fired, you're on a performance plan, you're getting a written warning. Anything that can be considered negative can fall under this particular purview. So if your client or you report sexual harassment or discrimination, you know, the first thing to consider is, what are your goals? Do you just want to quit and move on with your life? Do they want to file a claim? If they want to file a claim, then, you know, we need to be cognizant of these particular deadlines because they come up really, really fast. You need to ensure that they reported the conduct to the employer. And along those lines, the employer does have to be given an opportunity to remedy the situation. Of course, this all assumes that they want to move forward with a claim. If they just want to quit and move on with their life and be done forever, you know, with whatever happened, then you don't have to worry about any of these things. But if they feel like they have some sort of recourse, then, you know, there's things that we need to be thinking about before we move forward. And, you know, if they have severe claims, or not even severe, but if they have what, you know, you guys would consider to be claims under the law, you should direct them to a plaintiff's employment attorney, because there are other administrative hoops that you have to jump through. For example, if their employer is a governmental entity, you have to exhaust a bunch of remedies. If they are, you know, still working there, they might have to be constructively discharged. There are just a whole bunch of things that sometimes need to happen before you can just file a lawsuit. So the state bar can help people get directed to a plaintiff's employment attorney. Obviously, you guys know that our firm represents plaintiffs, but there are a ton of really great plaintiff's employment attorneys in Arizona, and they will be glad to help you however they can. The other resource I want to tote is Time's Up. So Time's Up is a product of the Me Too movement. It has been largely funded by a lot of celebrities. So there have been a ton of celebrities that have set up this foundation, and this foundation funds sex harassment claims. So, or even defenses, just depending on the facts. If your client's outside of Arizona, then they can just call Time's Up and say, here's what happened, can you direct me to an attorney? And Time's Up has a network of national attorneys that they will direct them to, and set them up with, so that we can get that process started. And what Time's Up does is it funds it funds lawsuits, basically. It offers grants for legal funding for people who may not otherwise be able to afford an attorney. You know, one of the issues that I have in practicing law is that personal injury attorneys have made it seem as if lawyers are free. Lawyers are not free. 90% of lawyers charge hourly, that's standard, but people see those commercials that say, we don't get paid until you win. That's just not how the law works, not how lawyers work. But that's generally the public's interface with attorneys are those types of ads. I would suggest that you largely ignore those and assume that your client will have to pay an attorney hourly. Time's Up can help them do that. And they're a really great organization. They have really fought for women's rights. They really held employers' feet to the fire. And I just can't say enough good things about this organization. So I am using Time's Up for two particular claims, and they're both sex harassment claims, but they're very different sex harassment claims. So the first one is Agato v. Blaylock. This is a pretty overt sexual harassment claim. The plaintiff was a low wage earner, and that's what we call them in the law, what we call people who generally make under $20 an hour. I know that that might not be the correct term that we use, you know, in a progressive society, but that's the term that the law uses. So that's what I'm going to use. She's a single mother of 5 kids. Her boss exploited and harassed her, coerced her into sexual intercourse, sent her very explicit photos, pornographic videos, and you know, engaged in the quid pro quo type of stuff. You know, if you do this, I'll give you $700. Well, for a single mom with 5 kids, $700 is a lot of money. She earned about 20 bucks an hour. That was a lot of money for her. She really thought it was an opportunity for her to move up in the world. And he just treated her like, you know, like someone he could throw away. And it's a pretty horrible case. We are in the process of pursuing a judgment. He did not appear in the case, so I can talk a little bit more freely about what's happening there. Because at this point, all the court has to do is determine how much money they're going to give her. So that one is really a sad one because she really didn't deserve that. And his conduct was sexual harassment defined. The second one, Stimson v. City of Tempe, is one I'm in current litigation with. The city, of course, has appeared and responded. So what I can tell you there is a little bit more limited. It is a sexual harassment claim. And my client, Ms. Stimson, was the only female garbage collector for the entire city of Tempe. And she has claims under Title VII for discrimination and retaliation. We are currently litigating those. Those will probably go on for the next 2 to 3 years. But she is being funded by Time's Up. She is a really wonderful woman. She tried really hard in her job. And I think we have some really good facts to prevail against the city. I find not just here, but in general, that any government entity is really, really hard to litigate against. They have unlimited resources. They have in-house trial counsel. Settlements generally have to be approved by the city council, which is made public record. And, you know, they don't want to settle with people, not because, you know, the client doesn't have good claims, but because they don't have to. So part of the reason I like doing plaintiff's work is not because my clients always have the greatest claims in the world, but I like holding employers' feet to the fire. Employers, especially in a capitalist society, have a ton of power over people. You could, I mean, employers can, in Arizona, can fire someone really for any reason or no reason at all at any time they want. And it happens pretty regularly, and that leaves people, you know, unable to pay their rent. It leaves them unable to pay their utilities, daycare, all the things that we have to pay for just to survive in America. So, you know, I really think that workers should be afforded more rights than they are. I think that employers need to realize that this is a two-way street. And the other thing that is good about at-will employment is that it works both ways. You can walk out anytime you want. And, you know, unless you have some sort of employment contract, which most of the vulnerable populations that you're working with probably won't, you know, you can quit at any time. The thing about quitting, though, is if you quit, you generally waive all of your claims against the employer. So if you voluntarily say, I quit, I'm done, you know, you need to be cognizant that if you think you have claims against your employer, you're waiving those by voluntarily walking off of the job. But you do have the right to do that. And I think that that's an important right that people exercise, because generally in America, we underpay and undervalue workers who keep our economy going. And you know, litigation is a really good way to expose what employers are doing, what their practices are, and how they treat complaints and how they investigate certain claims. So with that, I mean, I'll open it up to questions. I'm happy to answer anything about what we've talked about. I'm happy to, you know, talk to you guys offline. I will say I can't talk to you about your personal claims unless I have run all my conflicts and done all the things to make sure that I can ethically talk to you guys about, you know, whatever it is you have questions about. But for now, I'm happy to answer general questions about the law, about the cases I just talked about to the extent that I can, and other practical questions you might have about how this process works, if you're going to file a lawsuit, that kind of stuff.
Okay, I'm going to go ahead and turn the recording off now too.
Okay.
So we'll do that.